Good afternoon. My name is Don Nguyen. I am a Florida bar licensed attorney specially appointed by the City of Titusville to serve as the magistrate for today's code enforcement hearings. These public hearings are quasi-judicial in nature. While formal rules of evidence do not apply, fundamental due process will be observed. Everyone with the case today will have the opportunity to present testimony. You may also present evidence or call witnesses to testify on your behalf. Please note that there is no public comment portion during code enforcement hearings. To speak on a specific case, you must either be the respondent or a witness called to testify. Everything said today will be recorded. All testimony will be given under oath. When you're sworn in, please state your name and provide your current mailing address so we have an updated record for sending any orders. The city will present its case first. Information may be displayed on the screens and documents may be provided by the city as evidence. The city's PowerPoint presentation will also be entered into evidence unless there are objections. After all evidence and testimony have been presented, I will make a ruling. My ruling will be reduced to writing and mailed to you. At this time, I will swear in all witnesses that are present. If you intend to testify for your case, please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you all. You may be seated. We will go ahead and move to the approval of the minutes from last month's hearing. Everything looked to be in order, so I'm going to go ahead and approve them as drafted. We're going to go a little bit out of order on the hearings. I do want to respect the time of the attorney that is present here, so we'll move ahead to the initial hearing on case number 25-49 for Walmart Stores East LP.
Good afternoon. I have three items to submit. The first is the notice of violation and affidavit. The second is the notice of hearing and affidavit. And the third is the cost recovery statement in the amount of $234.19. So once again, this is the initial hearing for case number 25-49. Our respondent is Walmart Stores East LP and their registered agent, CT Corporation Systems. The violation address is 3175 Cheney Highway in Titusville, Florida. And we have one violation this afternoon. That's section 20-214 stormwater maintenance enforcement. So the initial inspection was completed on November 14th of 2024. A copy was hand-delivered to the manager on duty. The date given to comply was January 14th of 2025. Certified letters were sent out to both addresses on November 14th, 2024. The registered agent signed for theirs on 11/25/2024, and the respondent's letter came back unclaimed. Our notice of hearings were mailed out on November 30th of 2025. Both certified and return receipts were assigned for on August 14th of 2025. And copies were posted at City Hall and delivered to the Walmart managers on August 26, 2025. So initially, the complaint was received from the Titusville Development Services concerning required detention pond aerator and landscaping around the pond not being maintained. Copies of the approved drainage plan and landscape master plan were provided. Inspection of the property found the fence around the stormwater detention pond was covered in vines and falling over. Overgrowth of grass and weeds were observed on the slopes of the pond and on the shared drainage ditch around the exterior of the pond. And the required trees and bushes around the pond were not in place. Photos were taken and the notice of violation was delivered. So I've had multiple calls and meetings on site with Walmart representatives and discussing what was needed and what what we needed to do to come into compliance. So as of July 30th, when I was completing the reinspection, all of the landscaping had been completed. The only item yet to be completed was the aerator needed to be functioning. So it had been ordered in July. In August, when they installed it, they were having issues with the power. And as of the inspection of this morning, the aerator is still not working. So this is Code Section 30-214 concerning the elements of the stormwater management system must be maintained in full compliance. So this is an aerial view of the property. This is for the Walmart stores. This is from the master plan, the approved drainage plan, and highlighted in yellow, it's a little small, but that's the noted aerator for the stormwater pond. This is the plant list. So these photos are from July 29th. It does show that all the landscaping has been installed. The fence has been cleared of the vegetation. This is from the August 26th, and this is the aerators in the pond, but again, not working. So the conclusions of the fact for this case is Section 30-214, the retention pond aerator is not functioning as required. And so we are requesting that the respondent correct the violations on or before noon of October 10th, 2025. And to obtain compliance, obtain the required electrical permit and complete the installation of the pond aerator. We are requesting that a fine of $100 per day be imposed if they do not come in compliance. And we're asking for the administrative costs in the amount of $234.19. And once the violation has been corrected, to call code enforcement for the reinspection.
All right, and the respondents are here
Yes, sir.
with counsel. Counsel, you want to come to the front, give me your name and
Good afternoon, Magistrate Nguyen. For the record, McGregor Love, 215 North Eola Drive. Thank you, and
I'm sorry, what was your name?
McGregor Love,
Is it M-A-C or?
McGregor. Last name Love, L-O-V-E.
All right, sorry, I thought that was the name of the firm you were with.
That's a very reasonable assumption, but no, my
Mr.
parents
Love?
decided to get creative with
All
my
right.
name. I want to thank Officer Wright. I haven't been involved with this as long as she has, but from what I have discussed with my client, she's been great to work with. So we really appreciate her work on this. And as she summarized, the last piece of this really is the aerator. We are ready to do that work, and it's not a significant amount of work once the permit is issued for the aerator. The only reason I would ask for 45 days instead of, I believe, what is maybe 30 or a little bit more than 30 days, is that we recently learned that the contractor actually inadvertently submitted the application for the permit to the county rather than the city. So now it has to be submitted today to the city, and we want to provide adequate review time for the city so that the permit can be issued and the work can be completed, which should take no more than a day or two. So we would ask for 45 days, but otherwise we agree with everything that Officer Wright outlined.
Okay. Does the city have any objection to 45 days?
No, sir.
All right, well, sounds pretty easy to me. Okay, that sounds reasonable. So I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. I find that respondent Walmart Stores East LP is the owner of the property of the address 3175 Cheney Highway, Titusville, Florida 32780. I find that all required notices were provided in accordance with Chapter 163 Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of Section 30-214 of the city code regarding stormwater maintenance exists upon the property, and respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. The corrective actions for these violations shall be, how do you word it exactly? You just have to fix the aerator, or what's the exact terminology there? I'm not too keen on stormwater maintenance myself.
Just complete the required permitting process and, yeah, the aerator needs to be operational.
Okay, all right. What she said. Additionally, I find that the city has incurred costs in the amount of $234.19. Such amounts shall be included in the order. Respondents shall be given 45 days, which is, I guess that would be October 25th. What day does that fall on? Is that? So let's not do that. So October 27th, which is that following Monday. Respondent, is that okay?
Yes, sir.
Okay. Respondent shall be given until October 27, 2025 to correct the violations. Respondent shall be responsible for notifying Officer Wright of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation by October 27th, a fine will be entered in the amount of $100 per day until the violation comes into compliance. Further and future violations of the same sections shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Thank you, sir. All right, give me 1 second. I'm trying to do something different and take better notes as I go along, since Miss Mickey's not with me anymore. She's listening though. Say hi to her. She's watching us from Tennessee. All right, let's see. Let me find Okay, let's get back on the regular agenda. Let's go back to our Massey hearings. The first one on the agenda is 25-36, which is for 419 Wager Avenue.
All right, sir. I have the notice of hearing and the cost affidavit for you today.
Thank you. Okay, you may go ahead.
All right. Again, this is 419 Wager Avenue. The mail-to address was 975 Nova Way. This is a Massey hearing for the junk and debris, the accessory structure, the fence, and the roof and drainage. Yeah, it was posted on the property. All the hearing notices were posted at City Hall and on the property. When I was on the property posting the notice, I talked to the tenant. The tenant pretty much advised me there was been no corrective action either on their part for the owner to do anything. This case was originally heard on August 11th. The respondent was ordered to correct the violations by September 5th. If not, the fine of $100 per day per violation would commence on September 6th and continue until compliance is achieved. As of today, the violations remain. I checked it this morning and there's been no corrective actions. And this is just a summary so you know. This is the fence damage. This is the junk and debris. More of the fence. Sorry, and on the side, the roof still has the blue tarp on the top. And that's just the posting notice, yeah. Yep. And the respondent's not here, so.
Have we had any communication with them whatsoever since
Nope.
the issue? And they didn't appear at that hearing either, did they?
No, sir.
Okay, all right. I find that based on the evidence and testimony presented, that notice was properly provided to the respondent, and the respondent did not appear. The evidence demonstrates that the property located at 419 Wager Avenue, Titusville, Florida, 32796 remains in violation. Specifically, sections 12-23 regarding junk and debris, 6-109, 302.7 regarding accessory structures, and 304-7 regarding roof and drainage remain on the property, and the property is not in compliance with the previous order dated August 18, 2025. Therefore, I find the city has established a continuing violation of the aforesaid provisions. Accordingly, a fine of $100 per day per violation commencing on September 6, 2025 is imposed and continuing daily until the violations are corrected. Additionally, the cost of $251.80 has not been paid. Yes, that's correct. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. The lien on the subject property may be subject to a foreclosure in the future. Done and ordered. Thank you. Give me 1 second. My computer crapped out on me while I was talking there. Okay, let's go ahead and move on to the next item on the agenda, which is 25-37 for 3700 Miriam Drive.
Okay, I'd like to enter in evidence to notice a hearing.
You may go ahead. Yeah.
Okay, the violation address here is 3700 Miriam Drive here in Titusville. Respondent is Jessica Cassell. Mailed to 3655 Valley Forge Drive, which is the address of record by the Brevard County Property Appraiser's Office. There was 4 violations on the property: junk and debris, overgrowth, swimming pool enclosure, and the pool itself. As of 11:05 this morning, they're all still in violation. The notice of the hearing was posted at City Hall on 8/26 and on the property, and certified mail and first class were sent on July the 30th, 25. All the mail has come back unclaimed. The case was originally heard on August 11th, 2025. The respondent did not attend the hearing. She was found to be in violation of the 4 code sections mentioned earlier and was required to correct on or before noon, September the 5th, 2025. If compliance was not achieved, the fine of $150 per day per violation would start on September the 6th and continuing daily until property is brought into compliance. None of the violations have been corrected. And still, that's the overgrowth still. Some of the junk and debris, it's all around the property. There is that beautiful pool water. And that's the enclosure that cannot be secured.
I remember these pictures.
Yeah. And the conclusion in the case is everything is still in violation, all 4 code sections. And our recommendation is to order respondents and that they didn't do it. So We also would like to, I said administrative costs for 128.53 and impose a fine of $150 per violation per day. And respondent must contact me to verify that the conditions have been corrected.
Is it Frank Lewis? Is that?
Yes, sir.
All right, sorry, just making sure. Oh, no, it's there in type, so, all right. We haven't had any communication with her whatsoever?
None whatsoever. Before the original hearing, we happened to catch a number for her on a document
Yeah,
from a previous sale where she had transferred some property somewhere else. No response since.
is the property vacant?
Yes, sir, it is. And there's no fence around the property at all. That's why the swimming pool issue to me presents such a danger.
Okay, all right. I find based on the evidence and testimony presented that notice was properly provided to the respondent and the respondent did not appear. The evidence demonstrates that the property located at, not 3655, that's the wrong one, at 3700 Miriam Drive, Titusville, Florida, 32796 remains in violation. Specifically, the property or the respondent is in violation of sections 12-23 regarding junk and debris, IPMC sections 302.4, overgrowth and weeds, 303.2, enclosures and swimming pools, and 303.1, swimming pools. The property is not in compliance with the previous order dated, I think also August 18th, let me see, August 18th, 2025. Therefore, I find that the city has established a continuing violation of the aforesaid provisions. Accordingly, a fine of $150 per day. That one's per violation, yes. $150 per day per violation is imposed, commencing on September 6th, 2025, and continuing daily until the violations are corrected. Additionally, the cost of $128.53 has not been paid. A certified order of this copy will be recorded in the public records constituting a lien on the subject property, which may become subject to foreclosure. The respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. Thank you. I'm on the wrong one. Okay. All right, let's move on to our last Massey hearing. And that will be for 25-48 Pop Florida Properties LLC.
No, I don't have a PowerPoint. They were in compliance as of the date. Everything was installed by the September 5th compliance date. The only thing we're asking is that administrative fees be assessed.
Okay. Let me see. How much was the administrative fees?
Oh, hang on. I need to give you the affidavit and notice of hearing for today's hearing for the file.
And could you put the administrative cost on the record?
Yeah,
Yes, sir.
They should be in there.
Administrative costs were assessed in the amount of $216.58.
All right. You know, it's weird. I don't even have a script that I read off for when it's actually complied with. All right, I find based on the evidence and testimony presented that notice was properly provided to the respondent. The respondent did not appear, but the evidence demonstrates that property located at, this is 3675 Cheney Highway, Titusville, Florida, 32780, is no longer in violation. And all fixes have been made pursuant to the order entered on August 18th, 2025. The administrative costs of the city still need to be recovered in the amount of, you just gave it to me, and I know it's back here, of $216.58. A certified copy of this order will be recorded in the public records. The respondent is, oh no, that's, well, I don't think I need to talk about a lien and foreclosure. I think we're good. So done and ordered on that one. Great. Okay. All right, so we'll move on to the initial hearing. So we only have the one left for today, which is 25-59, Mr. Michael Ray Stinson and Holly Stinson of 2755 Tomoka Avenue, Titusville, Florida, 32780.
Yes, sir. I have 3 items to present: the notice of hearing, the notice of violation, and the cost affidavit for $181.36.
Thank you, sir. You may proceed.
Violation address again is 2755 Tomoka Avenue. The initial violations were accessory structure for the fence and roof and drainage for roof damage, which has been complied, so we're just talking about the fence today. The initial inspection was on April 15th. Date given to comply was May 19th. The violations were mailed certified in first class and signed for on April 23rd. The hearing was mailed certified in first class on July 30th. That was also signed for and was posted at City Hall and on the property on August 26th. For April 15th, I received a complaint about the fence was falling in the neighbor's yard at this location. I observed damage to the fence and the roof when I did the inspection. The roof repairs have been made, but the fence has not been taken care of. I had no contact with the respondent until today. He is here. Several re-inspections were conducted. This is the initial picture of the complaint from the neighbor about the fence that was falling, and that's the picture. Since then, the neighbor who made the initial complaint put a new white vinyl fence up, so this fence is still on his property. It just needs to be removed. These are pictures of the other side of the damage. Those have been corrected, and these are the follow-up photos just showing that the fence is still visible, that he just needs to remove the fence on his side that it's fallen. And again, just the fence needs to be repaired or replaced or removed, as we discussed with him today. If the respondent doesn't comply by October 10th, 2025, is requested a fine of $50 per day be imposed and continue until the violation is corrected, and to contact me. He is here today. There was miscommunication on which fence sections he wanted removed, or I needed removed. He's well aware, and he said he should have it done by this weekend. He agreed to the 30 days. I have no doubt that he'll get it taken care of before the next hearing on October. Can we waive the administrative costs unless he repairs the, you good with that? Can we waive the administrative costs unless he doesn't repair? And just table the administrative costs. If he doesn't come into compliance, we can discuss it next month, but as long as he comes into compliance, I would see waiving it.
Okay.
And he's here and he agrees to.
Mr. Stinson, do you have anything you wanted to add, or are you good with that?
No, he explained it perfectly. I misunderstood that it was
Okay.
two fences. I did one fence, but I didn't understand that it was the other fence also.
Okay, perfect. Easy enough. So I've accepted and considered documentary evidence, including photos and sworn testimony relating to this matter from city staff. Let me bring this up. Because it's not your name personally on there, right? I find that respondent, what, is it Michael Ray Stinson or Holly Stinson Revocable Trust? What's the actual entity that owns the property? Because it says them as trustees on there.
But you own the property, right? It's under a
I
trust?
own the property, but was placed in a trust
Yeah,
through the Broom Law Firm.
but the name of I have to put down the respondent, which is the property owner, which would be so-and-so Revocable Trust. Is it, do you know what the name of the trust is exactly?
I think it's the Michael Ray Stinson and Holly Stinson Revocable Trust.
Yeah, I think that's what, all right. I think that's what I saw there a second ago.
It's whatever Chris.
Yeah, okay.
I didn't really understand it, but he told me that it was, like, something I should do.
All right. All right, give me 1 second. Let me make sure I got that right for the order. I'll look it up the property records real quick. 755 Mocha. All right. It is the Michael and Holly Stinson Revocable Trust. All right. I find that respondent Michael and Holly Stinson Revocable Trust is the owner of the property with the address 2755 Tomoka Avenue, Titusville, Florida 32780. I find that all required notices were provided in accordance with Chapter 163, Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of Section 6-109 IPMC Section 302.7 regarding accessory structures and fences exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but due to a misunderstanding, have failed to do so as of this date. The corrective actions for the violation will be to fix the fence so that it's not falling over. Additionally, I find that the city has incurred costs in the amount of $181.36. Respondents shall be given until October 10th to correct the violations. Respondents shall be responsible for notifying Officer Flanagan of completion of such corrections, who shall then confirm the status of the violation. Assuming it is corrected prior to October 10th, the city's costs will be waived. If the respondent fails to correct the violation by October 10th, a fine will be entered in the amount of $50 per day until the violation comes into compliance, and further consideration for the administrative costs will be had at that time. Further and future violations of the same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Thank you. All right. All right, thank you, sir. Do we have a code enforcement manager's report?
No, sir, no report today, but however, we wanted to let you know that effective November, the start times for the municipal code hearings would be at 1:00 p.m. in place of 2, and we're moving forward, changing all the correspondence and web pages to reflect that.
Great. And I appreciate you guys being accommodating to my schedule for that. If there's nothing else, I will go ahead and adjourn the meeting at 2:35. Great. Thank you, guys.